Good evening. Sorry, there was some issue, a technical issue. I'm not very good in technology, so I had to take assistance of my son. Uh, First of all, I must thank team latestlaws.com for bringing us together for this talk. Talk would be on career in arbitration, and this is invariably the question I get from the law interns, the new lawyers, budding lawyers, and even people at their advanced stage of their career who want to get into arbitration. So we thought that we will talk about career in arbitration today. Uh, Before we talk about career in arbitration, in nutshell, let us also talk about what is arbitration and whether domestic arbitration, where both parties and parties are from same country, is different from international arbitration, where one of the parties would be from a foreign jurisdiction. Arbitration is essentially a private dispute resolution mechanism which is conducted in private and confidential. It is a confidential process. The procedures which are used in arbitration are tailor-made as per the requirement of the proceeding before the tribunal. It is in one way, if we have to describe what is the difference between court litigation and arbitration, uh, one answer which we can give is that whenever we go to court, uh, court procedures are guided by and governed by the Civil Procedure Code. That is the case in every jurisdiction. Every country has its own Civil Procedure Code. And irrespective of the nature of the dispute, irrespective of the number of the parties in courts, all proceedings will be decided as per the provisions under the Civil Procedure Code. So there is no flexibility uh, in terms of procedure, in terms of timing, and which obviously affects the cost. There are multiple reasons why parties opt to go for arbitration. There have been many surveys globally which indicates that invariably all commercial parties prefer to go for arbitration because of its inherent advantages. Arbitration uh, is one stop shop, so you have no second chance. There is no provision of appeal as we have in the cases of court litigation. Like in first appeal, the first appellate court can go into facts, can go into all the laws applicable. You have provisions for second appeal, where again, on the substantive question of law, substantial question of law, court can intervene. But in arbitration, you have one chance and you have to give your best. Even if you have provisions for objection to the award, it is on a very, very limited ground on due process and the public law issues, not otherwise. That's why it is said that arbitration is as good as the arbitrator, or arbitration is as good as the other stakeholders, the lawyers, the parties, party representatives. I'll start by saying today that today I would request all of you to define arbitration in your own ways and keep defining arbitration after every 3 months. And you will find more you learn about arbitration, your definition of arbitration will keep changing. So, this is one way of estimating you about your progress in arbitration. What is the relevance of arbitration? Why so many young lawyers, senior level lawyers, senior level bureaucrats opt for arbitration? Uh, as per a rough estimation, if I give the rough estimation, around 70% commercial disputes are decided through arbitration. Almost 100% international commercial disputes are decided through arbitration. So therefore, question is, can you afford to not be in arbitration, not think of arbitration as a career option? Answer obviously is yes. And another immediate issue would be, does it compensate you well? I must say that it really compensates you well. It compensates you much better, in much better way than litigation does. Domestic arbitration, arbitrators, I sit as arbitrator in many cases. Invariably, we charge 2 lakhs per 2 hours, 1.5 lakhs for 2 hours, and proceedings goes on for number of hearings. International arbitration, even in domestic arbitration, now you have if parties have not agreed for fees, and parties, if court is appointing the arbitrator, you have Schedule 4 of Arbitration and Conciliation Act. That also compensates you well. In international arbitration, if it is institutional arbitration, you have fees prescribed under the respective rules, and they again compensate you well. In investment arbitration, I'll give you one number. A couple of years back, we had one investment arbitration award of 50 billion USD. And in that case, claimants' lawyers, claimant lawyers were paid 90 million USD. And respondent lawyers, state lawyers, were paid 35 million USD. Now you can imagine the number you have to put after 90 and 35. So it compensates you well. What are the career? You can become arbitration lawyer, you can become arbitrator, you can become in-house arbitration counsel, you can become international bureaucrats. There are a lot of international institutions who engage arbitration professionals. You can become tribunal secretaries in the early stage of your career. You can get associated with arbitration institutions as case counsels. And the next question would be, who all can become arbitrator? Now, 2019 amendment says that, gives you the list. They say that you should have minimum of 10 years of experience for a lawyer to become arbitrator, or for other professionals. Broadly, I would say that lawyers can become arbitrators, chartered accountants can become arbitrators or arbitration professional or lawyer, company secretaries can become arbitrators, engineers can become arbitrators, architects can become arbitrators, quantity surveyors can become arbitrators. I know the biggest arbitrator from Malaysia. He is, by qualification, he is an architect. Biggest construction lawyer in world. The couple of names which I can take of Sir Vivian Ramsey. He was Technology and Construction Court judge in UK. Now he is chairman of Singapore International Commercial Court. He was editor of Gittings on construction law. He was an engineer. Mr. Robert Getskill, one of the finest construction dispute arbitration. He was engineer turned lawyer. In India, we have a few engineers. They are doing quite well. So all professionals. In fact, recently I had occasion to sit with 2 retired bureaucrats, and they did a very good job as arbitrators with me. I was the chairman in those arbitrations, and they were no less than any other lawyer, I would say. Now, question is how to start your career as arbitrator or arbitration lawyer. Thumb rule is that earliest the better. So if you are a law student, you should start looking at this career option from the day you go to a law school. Start taking extra interest in the subject of arbitration. And when I say start taking interest in arbitration, and this applies to all across the board. I'm not only talking about domestic arbitration. I'm saying arbitration as a whole. So start taking interest in arbitration, domestic arbitration, international arbitration, investment arbitration. In fact, in arbitration, domestic or international, now this is the era of specialization in arbitration. In India, around 60% of arbitrations, big arbitrations, are construction arbitrations. ICC Paris came out with its report a couple of years back, and they said 40% of their arbitrations were construction arbitrations. Now, construction arbitration is, in fact, what we call this different breed of animal. It has its own peculiarities and its own attributes. So, start early and try to take interest in this subject of arbitration. Read your other subjects, but keep following this subject. Now, obviously, I'll deal with what all to read, how to read, but start your career at the earliest. Don't believe and assume that arbitration is another form of litigation. It is not. Similarly, international arbitration is not similar to domestic arbitration. They have got their own specialities, peculiarities. They have got their own attributes. You need to have different kind of skill set. Just because somebody is a good litigator does not mean that you get appointment as a arbitrator or you will be cited as a arbitration lawyer in a case. Parties will go to only those who are having a speciality in arbitration. For law students, it's very important that they start mooting in the law schools. Some of the popular moot courts like Wish Vienna, Wish Hong Kong, Wish East, we call it, which happens in Hong Kong. I have been judging these moot courts for long. In this process, you get to learn, get to know how to. You get to learn a lot of the advocacy skills. You get to know how to prepare your memorials. You read institutional rules. You read CISG. So this really helps in big way. One should start writing journals, articles in journals. You write articles, you write blogs, you write comments, your comments on different blogs. Try to find out a speaking opportunity wherever possible. That helps you in a big way. It gives you visibility. In fact, one of the important thing is this is a very common question I get from a lot of arbitration professionals. They say how to break into this arbitration, how to get into this arbitration world. And answer lies, and one answer is work comes from peers, work comes from your co-arbitrators, work comes from the arbitration lawyers. And it all starts with your visibility. It all starts with your interest in the subject. Early you start taking interest in the subject. Your colleagues in law school will get to know that you have interest in arbitration. And after you become lawyer, after you start practicing, those colleagues will start approaching you that, hey, you are doing arbitration, how are you doing? And then get to know you, and then they will start referring you cases. Internships with the people who are doing arbitration, particularly international arbitration. Sometimes you get to see the websites of lot of firms. They say that they are doing arbitration, but you try to find out whether they are also doing international arbitration or not. Because if you want to get into international arbitration at some stage of your career, it is important to have experience of international arbitration. If you start working with somebody who is doing international arbitration, you will start following international arbitration. You will start following your senior, and it really helps. Another way of learning is that doing internships or clerkship or joining arbitrators who are doing arbitration. I get a lot of such requests, and I get a lot of interns and people because I work as arbitrator. I sit as arbitrator. I act as counsel. So a lot of people come and they say, "I want to intern with you because you sit as arbitrator." So there are people who are sitting as arbitrator who have got experience of international arbitration as well. It is a good experience. It will be good exposure. And another important thing is, if you plan to do arbitration, don't think that litigation is alien concept to this world of arbitration. No, it is not. Uh, do litigation, you will get to know procedures. Obviously, at later stage when you do arbitration, you will learn to mold the procedures. You will learn to uh, play with the procedures. You will learn how to uh, mix the procedures. But it's good to know, and it's always helpful that you know court procedures. It is always good to know the basic rules of evidence in court. In court, in litigation, you get to observe cross examinations, which is very important aspect of any arbitration. So it really helps you if you go to court. Obviously, one would immediately ask a question that Arbitration and Conciliation Act says that CPC doesn't apply, Evidence Act doesn't apply, but you are saying that we should go and learn CPC and Evidence Act. Question is, unless you know what is CPC and Evidence Act, how will you know what doesn't apply? So it is important. Secondly, in India, in domestic arbitration scenario, uh, most of the arbitrators are having legal background, and they invariably use the typical court procedures. So there you cannot say that I don't know civil procedure and therefore I'll not be able to answer your question. So do that, and thereafter there will be a stage of unlearning at some stage when you go deeper into the this arbitration world. Uh, in fact, uh, with the globalization of economy, obviously international transactions have increased, international disputes have increased, and requirement of and the interest in dual qualified professionals have also increased. So they get age. So that is one thing one can keep in mind. And another very interesting development we have seen in last 8-10 years is that a lot of arbitration professionals are getting into mediation because lots of the skill set which you acquire as arbitrator or arbitration professional are needed for mediation. Not everything, but this is the trend, and so it is good that at early stage of your career you also start following mediation. Uh, and the last point under this particular head would be that try finding a mentor. It really helps. It really helps. The mentors can do hand holding. They can really guide you wherever you need advice. So that would be another interesting thing to go for. Now, before I move ahead, I would like to discuss with you, and which is invariably the query by all, what to read for arbitration. So I would say that first of all, you should read Arbitration and Conciliation Act, that is your domestic legislation on arbitration, which gives you legal framework for the arbitration. Though we say that arbitration has nothing to do with court, but that's not the case. Arbitration as a process always need court assistance and assistance of the sovereign. So that's why you have arbitration legislations in every jurisdiction. So you must know your own arbitration legislation. Uh, Second thing you should look at is Law Commission's report, latest report of 2015 or 2014, I think, that was under the chairmanship of Justice A.P. Shah. And based on this particular report, you had substantial amendments in Arbitration and Conciliation Act in 2015. So that report would be of help if you want to understand your amendments properly. In 2019, again, we have seen amendments in the Arbitration and Conciliation Act. And these amendments had its genesis in the report of Justice B.N. Sri Krishna, which was a high-level committee constituted by Government of India. In fact, I was also invited to give my thoughts and presentation before the committee. I gave my thoughts, and I had made a point that accreditation of arbitrators is something we must look at. And in fact, it has been accepted, and now you have a requirement of accreditation for arbitration, for arbitrators. And in fact, you will find my name mentioned in the committee's report as well. Now, you would know that your Arbitration and Conciliation Act is based on ancestral model law. So United Nations wanted consistency amongst the arbitration legislations in different jurisdictions. So United Nations came out with this ancestral model law. And if you read the model law, in fact, most of the provisions of 1996 Act were identical to the ancestral model law. Now, all major commercial all major countries involved, all major jurisdictions involved are having their legislations, arbitration legislations based on the ancestral model law. So if you read ancestral model law, you will get to know the arbitration legislations of many countries. It becomes very easy. In fact, during this lockdown, this COVID-19 lockdown, I've been involved in one emergency arbitration seated in Japan, Tokyo, under the JCAA rules. It just got over on 2nd of April. Now I have started the main arbitration. It's again under the JCAA rule. I was going through Japan Arbitration Act. It is almost very close to the ancestral model law, and in turn very close to our own law. So it helps. Now, if you want to understand, like if I ask you that if today you want to understand a particular provision of constitution and there is some interpretational issue, or you want to really understand why a particular provision was written, what was the philosophical basis, theoretical basis, what was the discussion behind that, what do? You just go back to the constitutional debate. You open the constitutional debate, and then you say, yes, this was the background. In light of that, you start interpreting the constitutional provision. Similarly, I'll encourage all of you to read something called ancestral Travaux Preparatories. That is basically the legislative history of ancestral model law. And in turn, it is the legislative history of your own arbitration legislation. And this is freely available on ancestral website. You just go on the website and you will find the history. So if you want to understand a particular provision of Arbitration and Conciliation Act, which is pari materia with ancestral model law, go through the historical background, legislative background. It will give you better insight. On the ancestral website, there is something called CLOUT, CLOUT. That is the digest of arbitration case laws from different model law jurisdictions. Model law jurisdictions means the jurisdictions where ancestral model law is followed. So you will get to know from the clot, which is again freely available on Ancestral website. You will get to know how a particular provision of ancestral model law has been interpreted in different jurisdictions. So that's again a good resource to refer to. Uh, so we talked about the legislative framework in different jurisdictions. Now, when you come to ad hoc arbitrations, where when arbitration happens not under any particular institutional rule, then it is called ad hoc arbitration. So parties simply agree with each other that we will have an arbitration, and they do not agree that we will have arbitration under any particular rule like ICC or ICA or ICADR or MCIA or CIAC, whatever. So what happens? Then you have ad hoc arbitration. In ad hoc arbitration, typically what we see is that parties do not agree for procedures. So ultimately, procedures are decided and determined by the tribunal. For that, very good reference would be ancestral rules, ancestral arbitration rules. It is different from ancestral model law, which we just referred. Ancestral rules are basically rules made for ad hoc arbitration. So, if you refer to ancestral rules, again, it is freely available on ancestral website. You will get to know what typically happens in a typical domestic arbitration. Obviously, domestic or international arbitration. Ancestral rules are made for, in fact, international arbitration, ad hoc international arbitration. So it is a very good reference. In fact, 2012, I was doing one arbitration in Singapore, and it was ad hoc arbitration, and it was under the rules of ancestral. So I was engaged by a law firm to represent one Australian company, and we were doing this arbitration under ancestral rules. So this is a very interesting read to in order to get to know how ad hoc arbitration really runs through. Apart from this, what you should read is institutional rules. So you can read institutional rules of one or two arbitration institutions, popular arbitration institution, that will give you a sense of the conduct of international arbitrations under the rather international institutional arbitration. So, for instance, you can read ICC rules or CIAC rules. These rules are again freely available. You can go to the website of ICC Paris, or you can go to the website of CIAC, and you can read them. That is very interesting thing to know. Apart from this, there is something called soft laws. What are soft laws? Like you have, if you are doing an arbitration, and when you are referring to law, what is the law you are referring to? You are basically referring to the legislation, arbitration legislation. In the domestic arbitration, that will be the Arbitration and Conciliation Act 1996. And in international arbitration, the legislation would be the arbitration legislation of the seat of the arbitration. Suppose two parties, one from India, another from Australia, enter into an arbitration agreement, they have a dispute, and they wanted to have arbitration in Singapore. Now, the arbitration legislation of Singapore will have its application there. And if parties had agreed to have arbitration under the, let us say, CIAC, Singapore International Arbitration Center's rule. So those arbitration rules will govern the arbitration proceeding. However, whenever there will be any conflict between the CIAC rules and the provisions of the Singapore Arbitration Act, that is called Singapore International Arbitration Act, then mandatory provision of that Singapore International Arbitration Act will prevail. So, but when we talk about soft laws, apart from these legislations, you have a lot of guidelines and protocols which are prepared by organizations like IBA, International Bar Association, another is Charter Institute of Arbitrators UK. Now they have got various guidelines and protocols. Like for international arbitration, as we were talking about a couple of minutes back, that Evidence Act doesn't apply in arbitration. Now, These days, in almost 60% of international arbitration, parties agreed to be bound by IBA guidelines on taking of evidence. Just to have certainty of procedures, or particularly the rules of the evidence, they would be agreeing to go by the IBA guidelines on taking of evidence. So, what is this IBA guideline on taking of evidence? It is basically guideline, some of the articles there which were prepared and produced by International Bar Association, which has got very wide acceptance all across the board, and in almost 60% cases, international arbitration parties agree for that. In fact, in two of my arbitrations which are going on in India, these are high stake arbitrations, more than $1 billion USD are at stake. Mistake. We have, with the agreement of the other side, have agreed to have IBA guidelines on taking of evidence as the rule of evidence, and it's going very well. So it is being increasingly being used in domestic arbitration as well. So this is a soft law, IBA guidelines on taking evidence. Similarly, you have multiple soft laws on experts, how experts are to be cited, what is their role. So CIArb, what you do is you go on the IBA website and you get to see now in your Arbitration and Conciliation Act, you have got Schedule 5 and Schedule 7, which is on conflict of interest, when arbitrator cannot be appointed and all of that. So where from you we got that? It is nothing but IBA guidelines on conflict of interest, which was in vogue for international arbitration community for long, and we have now incorporated this in our legislation. So you can understand the importance of these soft laws, and because these are prepared by finest brains involved from all across the jurisdictions, from different legal cultures, from common law culture, from civil law cultures. So go to IBA website, go to Chartered Institute of Arbitrators UK's website, and you will get to see a lot of protocols and guidelines, how to write award, how to award interest and cost, all of this. For everything you have guideline. So it makes everybody's life easier if you are aware of these guidelines, because they are prepared by very experienced arbitration professionals. Apart from what all I have discussed so far, I will also encourage you to read Exceed Awards. You must be aware of Exceed Convention. Though India is not a party to this convention, Exceed is an arm of World Bank. Though India became a signatory to the World Bank, India is one of the first signatories to the World Bank in 1950 or something, but we have not yet signed the Exceed. So basically it is for investment arbitration, but India is not a signatory. But Exceed or investment arbitration materials are generally published, because generally these are not confidential proceeding, because you have states involved. So parties have option to opt out or opt in so far as the confidentiality issue is concerned. So Exceed Awards, interim awards, and so this is something very important. You should try to read. In fact, ICC's awards, which are obviously confidential in nature, but are published by Kluwer in their ICC yearbook. And what they do is they mask the name of the parties and all those informations which can connect you to the identity of the parties. So they will redact them. So, but you can get to see how those awards are written, because since, as I said in beginning, arbitration is a confidential process. So like court judgments, these are not reportable, but these are the ways how you can get to see how arbitrators are deciding cases, how you can get to know about the decision making process, you can get to know about the different due process aspects and all of this. Next would be, you should read arbitration law reports. Like in India, you have various law reports which publishes arbitration cases. You have recent arbitration judgment. In fact, I have been there in the editorial board for long, you have arbitration law reporters, and now in any case you have got Manupatra, you have got SCC online, so you can learn all arbitration related cases. You should also refer to foreign cases, foreign arbitration cases. See, arbitration makes you international, and I would say international citizen, and you should have this in mind from very beginning, that you should not confine yourself only to the domestic legislation, domestic cases. You should widen your horizon, because it helps you in understanding your own domestic arbitration in better way. Then you should read arbitration journals. So now you have a lot of law schools which are coming out with its own journals. I'm in editorial board of many of them. Good articles are being contributed by people. You have a lot of journals which are being published by the reputed arbitration institutions, like Chartered Institute of Arbitrators circulates among its members the journal called Arbitrator. I forget the name. One is Resolver, another name I'm forgetting. Similarly, you have London Court of International Arbitration, LCIA. They again circulate amongst their own members the very good journal called Arbitration, I think. So try to do that. Apart from this, you have interesting blogs being written. Like Kluwer has its own blog on arbitration. You get to see fantastic articles coming on these blogs. Uh, and apart from this, you should read, as I said, CPC. You should read Evidence Act. And now, when it comes to books, this is very common question: what all books one should refer to? I would say, as arbitration professional, or somebody who intending to be an arbitration professional, you must know the importance of quality books. This is an era of information, so you have lots of books, lot of informations all around. Don't jungle your, don't clutter your mind. So try to refer to one or two good textbook which can really help you. So when it comes to books on arbitration, I would suggest try to read a student edition or the enlarged edition of Gary B. Bond. Second is a very popular book which is referred in a lot of law schools in this part of world, and in the European countries, a book by Redfern Hunter. And one book which I find very interesting and very useful, which is generally referred in US law schools for arbitration, is written by Margaret L. Moses. Margaret L. Moses, by Cambridge University Press. It's a very interesting book, thick book, paperback book, very interesting book. Apart from this, you should know the good books which are being published, which are available in all developed, in all countries, on at least in all developed jurisdictions. It really helps knowing good books. It really helps. One question which comes from law student is, does LLM work or helps? Yes, LLM in international arbitration uh, works. It helps you. It helps you. It gives you good grounding. Um, Another important aspect is, and I would give emphasis on this, I'll encourage all of you, whatever is the stage in your career, whether you have not yet started, you want to start, you are doing it as a litigator, uh, try to attend as many conferences, seminars, and workshops as you can. It really helps. It really helps. It not only enhances your knowledge, it also helps you in giving you visibility. It helps you in connecting you with the the people who are having who have achieved something in this arbitration world. These workshops. Now, one important aspect I would like to touch upon is invariably what I see in law schools, the way this subject of arbitration is being taught. It is my sense. I am going to take classes in many national law universities and other colleges. What I have found is that the way these subjects are taught, somehow it is not complete. It is not structured. They will get to know in their classes uh, aspects and topics in piecemeal. So it doesn't serve the purpose. So try to attend short time courses if it is available. You can attend the workshop. In fact, I'm going to take a workshop. I'm going to teach in a workshop starting from 30th, if I'm not mistaken. It will be 7 days workshop, and I'll be teaching every day 2 hours every day for 7 days. So people who are interested in arbitration, who will have time to really attend this, can join. Uh, so this is something important. So like you have summer courses, short-term courses in many foreign universities. So try to join them. Uh, Another thing which helps you is become a student member of or full-time member if you are already in profession, or member of various arbitration institutions. It really helps. Like for students, CIArb, Chartered Institute of Arbitrators, UK. In fact, I have been their director in India for last 12 years. I am also fellow of Chartered Institute of Arbitrators. I am their accredited tutor. So this is how I teach for arbitration. Now, these organizations like CIArb gives free student membership to law students. So this is very interesting thing to go for. LCIA does that, gives student membership. ECA does that, ICCA. SEAC does that. In fact, what I am doing is I have asked the organizers, Mr. Divyans Rathi, who has himself done LLM from UK and came out, and he has started this initiative, and I must say that he's doing an amazing job. I have asked him to circulate in your comments section or wherever it is possible database. I have culled out a database of CISG, which gives you the link of all arbitration institutions which are giving membership, which is giving link of all blocks which are relevant blocks for arbitration, which is giving link of LinkedIn, which is giving link of various institutions. So this is amazing database, and if I have to go through all of these one by one, but then time will not permit me, so I will not go through that. So you can have access to that, and Divyans will work on this. Uh, Apart from this, another important aspect I would like to emphasize is uh, how to further your career. Now, one is that you start your career. Then another question is how to further your career and how to make it sustainable. So it is of relevance not only for the people who are planning to start their career in arbitration, but also for people who are wanting to join this at some stage of their career, or they want to, or for them who want to come into this arbitration world after the retirement. It is of great importance. Uh, in fact, uh, recently I was speaking in a conference in Singapore, and one question was asked on this like this. So my answer to this is how to make you further your career and make it sustainable. I said Answer lies in one thing, and I said that is training, training, and training. So continuous training, continuous learning program. In fact, in India, somehow we have no concept as such as of now for continuing learning program. But now Bar Council of India is also considering this. In fact, late Professor Madhav Menon had started one initiative under the aegis of M.K. Nambiar Trust, which was set up by Mr. Venugopal, the Attorney General of India. And I had designed their arbitration course, which was for 5 days. It was all meant for the lawyers, senior level lawyers, the law professors. A lot of judges used to come, and I have been going and teaching for last many years. Uh, so this is about training. Now, attributes of arbitration professional. That is again very important. What are the attributes which are required of an arbitration professional? I would say knowledge of arbitration law, very important. Knowledge of commercial laws, law of contract, a specific relief act, transfer of property act, partnership act, companies act, very important. Read them. As I said, now this is an era of a specialization. So in arbitration, you have construction arbitration, which I promote in big way because I am founder chairman of Society of Construction Law UK. So I founded that in India, and I have been chairman for long. And we promote construction law and construction arbitration, which has got its own peculiarities. And so try to read as much as you can about construction law. Now, so knowledge of law, knowledge of arbitration law. Next thing is you should consciously work on your advocacy skills. And please appreciate that advocacy skills, in any case, you need for courts. In arbitration, the advocacy skills are sometimes slightly different. So you should learn those skills. In fact, that includes writing skills, oratory skills. Knowledge of industry is very important. If you have a big construction dispute, the party, the disputing parties will go to that lawyer who knows arbitration plus one who knows about that particular industry, the requirement of that industry. It makes everybody's life easier. So that is about awareness. I'm just telling all of you that you should be aware that if you want to do arbitration in a particular specialization, like a sports arbitration, you have merger and acquisition arbitration, you have joint venture arbitration. These are different, like maritime arbitration. These are different specialties in arbitration. So it is not only about knowing arbitration, it is also about knowing a particular kind of arbitration. So that is again very important. And most important aspect is awareness about ethical values of being an arbitrator, of being an arbitration lawyer. Anybody who wants to take up this his career in arbitration must know this is one thing. Your ethical values are going to take you a long way. It is a small world. So therefore, you have to be upright. You have to be honest. You have to be honest to the tribunal. You have to be honest to yourself. You have to be honest to the client. You have to do hand holding to the client. You have to do hand holding to the arbitrator. In any arbitration, if arbitrator is in some difficulty, he would look at that particular lawyer in that particular proceeding, in whose ethical values he has got better respect. So these are some of the aspects which one should keep in mind. And typically, one thing which I find missing in arbitration, the domestic arbitration in India is, and as I said, arbitration is as good as arbitrator. So arbitrators must know invariably that doesn't happen in India. I have seen in my experience, invariably in every case, arbitrators will not go through the file till the stage of final hearing. And before that, you have multiple hearings taking place. It is something not done. You should get to know the case at the earliest possible opportunity. You must read the file. In international arbitration, arbitrators on a very first day, whenever I sit as arbitrator, in the very first hearing, the moment I have got some paper, I tell the parties, the ladies and gentlemen, please take it that I have gone through your file. Or if I haven't got the file and the one in the very first procedural hearing, I require the parties to address me on the merit of the matter for half an hour or 45 minutes, so that it gets me some sense of the matter, so that I can be in control of the proceeding. So this is something very, very important aspect one every arbitrator should be aware of. You should be aware of learning of flexibility of procedures. You should know how to manage documents. Arbitration, particularly big arbitration or construction arbitrations, are document heavy. So I'm talking about, obviously, tomorrow you are going to sit as arbitrator. So you should be aware of the requirements of an arbitrator from the very early stage of your life. How to manage documents. It's not that easy. You have thousands and thousands of documents. So you should develop that art. Obviously, for that, you may have to have another class, how to manage all of this. Award writing skills. You have award writing guidelines and protocols of even CIArb. In fact, Chartered Institute of Arbitrators conducts exam for award writing for whoever wants to get their accreditation. You should be aware. Every lawyer, every budding lawyer, every law student, every arbitrator, every arbitration lawyer must be aware of international best practices on arbitration. You can't be happy with just knowing typical domestic arbitration, which sometimes remains replica of court litigation, and then you say that I know arbitration. No, I'm sorry, that's not done. Arbitrators are to be bold. They have to take decision. So sometimes they may have to annoy the co-arbitrators, they may have to annoy the parties, but you have to take decision, you have to be bold. And I'll not, now time is getting up, so I'll end my talk by talking about accreditation and certification. Suppose somebody wants to be an arbitrator, somebody wants to be an arbitration professional. Is there any accreditation available? Yes, there are accreditations available. Chartered Institute of Arbitrators UK gives accreditation, which is globally recognized, which is gold standard accreditation. If you have got the accreditation of Chartered Institute of Arbitrators, and particularly their highest level of accreditation, that is of fellowship, you don't need any other introduction in the entire international arbitration world. If anybody, and if you are fellow of Chartered Institute of Arbitrators, you can write a suffix after your name, FCIArb, fellow of Chartered Institute of Arbitrators. That is something one should always aspire for. Like if you might have seen my name, there is a suffix after my name, FCIArb. So now wherever I go, anywhere in world, I don't need any introduction. People know that yes, if you have got fellowship, you would be knowing arbitration, international arbitration, no less than anybody else. So try to go for this accreditation. This is amazing. There are other institutions which are giving fellowship. In fact, I am fellow of 6-7 such institutions, like Prime Disputes give that. So if you are the arbitrator, if you are the fellow of this, so you can write FPD, Prime Disputes. Like Malaysian Institute of Arbitrators. So I'm also FPD, Malaysian Institute of Arbitrators. They give FMIAR, Malaysian Institute of Arbitrators, FMIA. I am their fellow also. Like there's another alternate AIADR, Asian Institute of Alternate Dispute Resolution. That's again based in Malaysia, Kuala Lumpur. I am their fellow also. So take these accreditation, take arbitration with all seriousness. Arbitration is a serious business. Arbitration, as I said, it's one-stop shop So you cannot afford to mess up with that. Equip yourself at the very early stage of your life whenever you can. Create the resources, infrastructure of knowledge in you, and don't think that I don't have international arbitration work today and who is going to give me international arbitration work tomorrow. Don't think of all of this. If you have created your infrastructure of knowledge, rest assured that people are going to come you, your peers are going to approach you, the clients are going to approach you, and you will never have any dearth of work. Please appreciate, today we have dearth of good international arbitrators in India, international arbitration lawyers in India. I wish and I hope all of you are going to fill up that vacancy. Thank you very much. And if there is any question, you can write in the comments section. I'll try to answer this, and you can get in touch with the organizers for this. Thank you very much.
Okay.